welcome you to the second appointment with the authors conferences. I would like to remind that this conference series aim is to achieve a better understanding of the contents of our latest publication, Volume 2, Number 2, to the direct contact of our readers and general public with our authors. I should like to ask all attending parties to switch the microphone off, please. Yes. As custom dictates, thanks and appreciations ought to be kept for the end, but I believe it's my privilege as overseer of this gathering to start instead by thanking first and foremost our guests for accepting our invitation to exchange ideas here today. Hence a warm thank you and welcome to Mr. Sharma and Dr. Caroli. Also to be thanked, I believe, is the Trento Student Law Review Social Media and Communications team for the excellent work and dedication demonstrated in organizing and publicizing these events. Thank you, dear friends, for the brilliant work. Now that custom is satisfied, I believe it's time to business. I would like to introduce to you today's speaker and discussant. Mr. Swapnil Sharma is currently a fourth-year undergraduate student, and he is pursuing an integrated Bachelor of Arts and a Bachelor of Laws with honors at the Manipur University in Jaipur. He is founding member and president of the Consumer Protection Cell, whose aim is to act as a bridge between victims that, well, yes, Mr. Sharma is the director, the president of the Consumer Protection Cell, and in which capacity he has presided over the conference on contemporary issues of consumer laws, which took place in April 2020 at Manipur University. Mr. Sharma will present us his article published in the latest volume of the review, titled Social Media and Accountability in the Cases Concerning Core Crimes. Well, 2 words on the topic we are here to discuss, and I believe the topic chosen for the article is particularly relevant and should deeply interest all of us, because it's common knowledge, really, that social media are currently expanding their influence on society and their relevance in the way public life is conducted. Without spoiling topics, which I'm sure will find the place in today's conference, also through, I hope, an active part of the public, I wish to set a spotlight on the novel and active approach the social media platforms have recently embraced. In fact, it appears that big tech social networks have shifted approach, abandoning the traditional abstentionism and, we may say, non-intervention policy for a rather more flexible posture towards the selection of the content they host. This is especially now continuing. Yes, I was saying about the active approach of big tech companies in selecting what can be published and who can publish on the social media. And to me, it's really clear. It's clear to me how this is linked with the subject of the article Mr. Sharma wrote, as it's really impacting on the role the social media can play in preventing crime on social media, but this can be discussed later. To help us to better understand and to grasp the contents of the article, we are relying on Dr. Paolo Caroli, who will serve today as a discussant to further develop and deepen the topic discussed in the paper. Dr. Paolo Caroli is Research Fellow of the Alexander von Humboldt Foundation at the Humboldt Universität zu Berlin and author of the monograph The Power Not to Publish, a study on the Togliatti Amnesty, published by Edizioni Scientifiche Italiane. He is also lecturer of international criminal law at the University of Trento. After obtaining a PhD cum laude in criminal law from the University of Trento, he was a postdoctoral researcher at the Memory Laws in European and Comparative Perspective at the Alma Mater Studiorum, University of Bologna, under the guidance of Professor Emanuela Fronza. He is also a lawyer and a freelance journalist. I'm sure we'll benefit from his consideration and remarks to gain a fresh and independent opinion. And now it's high time I yield the floor to our author, Mr. Swapnil Sharma. Thank you.
Thank you so much for the introduction and everything. And so before starting with presentation of paper, let's build up why I start writing this paper. So basically, this all started when I observed the role of social media, which is constantly increasing and interfering in the daily life of citizens, particularly in India. You see, because whenever there are riots, whenever there is something, if you must have heard of farmer protest in India, it's an emerging issue. Like I can connect that to my paper. The activists like Greta Thunberg, they have shared something called toolkit, and that toolkit had nothing inoffensive, but that triggered a fire in social media and in Indian courts as well. So social media is deeply affecting our daily life, but unfortunately, we don't have in international law and in India, we don't have any such strict regulations to monitor that. Right. So I thought of writing this paper on the social media, but then eventually it turned out to be start with cyber jurisprudence and then determining the cases in which liability of the people who are using social media, how can that be determined? So for the sake of discussion, I'll divide this paper into two parts. In the first part, we'll discuss the applicability of cyber jurisprudence in the law. And in second part, we'll discuss the applicability of Rome Statute. That is very important because apparently that's the most effective statute that we have to deal with the international issues which arise in international criminal space. So to start with, first of all, it's very crucial to set up one thing in our mind, and the assumption which I've carried out through my paper, and I have established also that we cannot achieve the modern solutions through the old techniques. We need some modification, we need some improvements on daily basis. So first of all, let's start with understanding what is the cyber jurisprudence. As such, there is no set out definition, no universally accepted definition of cyber jurisprudence. So I was bound to go back to the times of Sir Thomas Hollins and other jurists who have tried to give a definition of jurisprudence and then try to evolve a definition of this cyber jurisprudence. So as I said earlier, cyber jurisprudence does not have a universal definition. So let's go back to the time. First of all, for the reference, we take the definition which is being provided in Black's Law Dictionary. It defines jurisprudence as philosophy of law. In very simple and primitive words, we can first of all consider it as philosophy of law. Then, if we go further, we can now state, according to Sir Thomas Holland, that jurisprudence is a formal science which rather focuses on the basic principles than the concrete details. Now this gives us a base for my further arguments, for my further contentions with regard to cyber jurisprudence and jurisprudence. So what I tend to argue, what I tend to establish in my paper is that jurisprudence is a base which will remain same eventually. The basic concepts like rights and duty will eventually remain same, but there are little modifications which we need to do. For example, if we go to the literature of Sir Thomas Holland, once he gave a comparison between the grammar of the languages and jurisprudence, which I find very interesting. Now, what he states is the grammar of different states has some similarities and has some dissimilarities. The same is with the jurisprudence. The law of every state has some similarities and dissimilarities. So these similarities in which we can find in every state is what we call jurisprudence. On my screen, I can see my internet connection is unstable. So kindly Do let me know if I'm stuck or I'm not audible at some point of time.
Well,
Shall I continue?
yes, please do continue.
Thank you so much. So what we can derive out of this right now is that jurisprudence is a progressive science which has a base, which does not change. If we can inculcate things with respect of time right now, but the base but out of the base it's like a tree. Jurisprudence is a root, and then there are stems which we can call law. This is what I derived when I studied different jurists like Sir Thomas Sowell and Jeremy Bentham and others. Now, when we discuss about relevance of cyber jurisprudence in modern world, there are basically two views. Broadly, there are two views. First, they contain first view for the first school of thought. It contends that jurisprudence is static, right? And so the existing substantive law can be either applied as they are or with some modification, but we do not need a separate regulation or a separate regulation and a separate jurisprudence for cyber laws. I personally find this argument very vague and ineffective in present times. The second school of thought suggests that cyberspace is a novel legal space, and hence we need and hence traditional principle cannot be applied, and hence we need a new jurisprudence for cyber laws. I do not completely support this school of thought, but then I inclined more towards this school of thought, because what I found that it would be best if we find a midway from both. See, it is well established that if we try to give entire new jurisprudence to cyber law, then it must be guided by the traditional principle of laws, which are drafted in documents of United Nations and general principles of laws. So the midway will be that we can take reference from the international documents and settled principle of laws, and then uh, the law should be allowed to evolve, and modification must be accordingly made. This is what we can do in the field of cybercrime, cyber jurisprudence. Now, in my next
Sharma,
segment,
might I suggest you switch off your video camera, hence perhaps we can hear you a bit better.
Sure. Okay. Am I clearly audible right now?
Yes, we can hear you slightly better.
Okay. So I think I should continue.
Yes, please.
Thank you so much. So in the next segment, I discuss the framework of international criminal justice system and efficiency of that system in context of technological development. So what baseline for this contention is that it's very simple to understand that International Criminal Court was founded in 1998, and it was eventually set up and came into force in 2000. But the use of computers, the use of internet has showed a exponential growth after 2000 till 2020. For example, the use of computers has risen from 42% in 1998 to 89% in 2016. Use of internet raised from 25% in 1998 to 88% in 2016. Then, most importantly, the use of social media has dramatically increased from just 5% in 2005 to 79% in 2019. This is of great importance to establish that our laws, the laws which international community followed and is unable to change due to political unwillingness, are obsolete and are not capable of governing the offenders of international criminal law, which have modern techniques. So what I try to say is the assumption on which the laws were based may not stand true now. Now, this is particularly true with regards to legal environment surrounding the technology, which will inevitably need to be considered an area in tumultuous development. Now, if we take into if we consider this data of information and communication technology, it affects a wide range of society. It affects almost whole society, I should say, because it is covering uh, approximately 80% area, and it must have been increased till now. More than 80% of area population is being covered. So almost whole of the society is being affected. Now, with this, a possible implication could be shift from traditional military aggression to a more sophisticated underhand informatic attack. What I tried to say is that international criminal court has an experience of trying the people for military aggression, of trying the commanders. But now the time has changed. Now it's time to shift the responsibility from military commanders to computer programmers, engineers, and security hackers, because they are constantly playing an important role in the society. Now, I would like you to consider the example of Myanmar genocide, the Delhi riots case, and other such riots in which the social media is playing key role, including the Capitol Hill attack. For example, in Myanmar case, Facebook was informed earlier that Facebook is being misused for terrorist activities, but Facebook showed no active participation, showed no active action in protecting these kinds of activities, which is very unfortunate, and it eventually led to killings of a large number of people. Same is the case with Delhi riots. You know, this is out of research paper, but it is very crucial for us to understand that Facebook has an algorithm which promotes hate speech. Now, this is not as simple as it may sound. Facebook has an algorithm which promotes the uh, content, which has ability to engage people for more time, and that content is definitely the hate speech content, because people get engaged in debates in the comment section, they react on that particular post, they share that particular post, and hence these kinds of post is being promoted on social media platforms like Facebook, Instagram, and others, and it plays an active role. But in my research paper, I question the liability of people who are using social media and committing crimes. Now, to consider, to examine the potential of that social media, the internet carries, it can be it can be imagined, or it is possible in today's time that advancement of technologies of such potential that it can be instrumental in documenting and reconstructing the harming attacks, including the attacks like including the heinous acts like the Holocaust. And this has been supplemented by various studies, the authors which have studied this thing for straight 5 years. This attack, reconstructing these attacks is possible through social media, through internet. Now, the propaganda and intent in cases of incitement through social media might, for example, be rightly established through the documented encouragement, and other relevant materials. But the court tend to act with defendants found responsible for mere political propaganda, because the use of such compromising element is insufficient to prove the intent to encourage the commission of criminal acts. Oh, the reference has been made to Pierre versus Attorney General. This is a case of US where the court stated, in simple words, I'll say that establishing the presence of general intent will not suffice the requirement. Now we are heading towards definition, or we'll head towards definition of mens rea, defining what the actus reus is in an international context, and that will that will conclude that there are very high standards in international law to set up a liability, and current laws are not sufficient to convict the offenders of cyber world. For example, let us consider the case of the Bamba et al. Case. Here, the appeal chambers of International Criminal Court decided in a majority decision to acquit the accused for the charges of war crimes and crime against humanity in the Central African Republic. Now, very interesting thing to note in this particular context is that the court held that commander lacked the responsibility, and basing the judgment on the fact that Mr. Bamba was not physically present and indeed was at far distance. This argument might prima facie sound logical, but this argument fails fails on the touchstone of logic and on the touchstone of justice by the fact that the commander was using a Thuraya satellite through which he was able to communicate to the subordinates. Now, which this made him possible to instruct, and it will not be viable to state that using some social media, being not directly present, will decrease the liability or the authority of that particular person. Now, it is necessary to examine if and how traditional jurisprudential guidelines keep the pace with current day challenges. A strict application of outdated jurisprudence to cases where advanced technologies are used as means of criminal action might also bring to an excessive expansion in applying the underlying no witness, no case principle in criminal investigation. Now, next subpart of this particular topic is the international criminal laws and jurisdictional challenge. This is the foremost thing which shall be considered by international criminal law. The jurisdiction is the foremost thing. I'll be dealing with Article 12, which is the cornerstone of Rome Statute, and then I'll be coming to Article 17 to discuss the applicability of these articles in context with the technological advancement which we have right now. Rome Statute, as we know, is an important source for justice in all cases, and including cases of cyber crimes. It does not clearly contains provision regarding international cybercrime, but I tend to find out the potential ways through which the, the provisions of Rome Statute can be applied. Coming to the preamble of Rome Statute, it sets the foundation for broader approach to the scope of and objective of the code. It states that most serious and heinous crimes must not go unpunished. Now, this section will focus on the problems with the narrower jurisdiction of ICC. Apparently, these narrow jurisdiction is a result of political consensus on getting this particular provision as a narrow provision, because most of the states were not willing to make it a broad provision because it directly affects their state sovereignty. So we can safely say that Article 12 is a compromise between providing justice and protecting state sovereignty. Now, what we are seeing with the increasing use of internet is that non-state actors are acquiring a substantial role to play. They are using the techniques, they're using the technology as states who directly promoted international action can avoid direct responsibility in international community, and there'll be no direct proof against them if we do not modify ourselves, the laws, the techniques in such a way to uh, to keep in pace with the technology. Now, what we see is that it is often difficult to exercise due to the fact that at certain times it is difficult even for the service provider to track the location of data. Now, here comes the power of technology, which can successfully evade laws. We all are aware with the deep web, with the dark web, with the crimes which are committed there, and the law is apparently not able to tackle them. And here is a problem which can affect a lot of people. We'll talk about genocide. Genocide is, in very primitive words, mass killing with other conditions applied. So this is able to affect the lives of thousands of people, millions of people, and hence a spotlight must be drawn on this particular concept. The nature of the crime which occur in cyberspace is more likely to pose a multi-jurisdictional complexity. For example, when criminal actions have been committed within the boundaries of one state, say it has been committed in the country which I live in, India, but the effects of such activities have an impact on other state. Let's consider Nepal, which is the neighboring country of India, for this particular example. Now, under these circumstances, the state has the option to invoke the effects doctrine. The effects doctrine, it states that if a state is affected by action, which has action or a crime which has been initiated in some other state, then the jurisdiction can be applied. It is basically an expansion of territorial jurisdiction. In this particular regard, the High Court of Zimbabwe was very progressive to state that traditional territorial law is being decreasingly appropriate for the principles of justice due to increased internationalization and globalization of contemporary society. Well, effects jurisprudence seems like a good option and a good answer to the jurisdictional complexity. But it poses the state's sovereignty problems. Now the consideration. lead to deem the effects doctrine will not established in international law and it is uncertain in nature. So it is clear that we do not have any clear law, we do not have any clear doctrine which can guide us through, which can help us through these kinds of complexity. Now, in my next section, which I'm going to cover, I'll particularly cover the problems with Article 12, the nature of Article 12 in context of cybercrime. Now, the Article 12 is designed to govern the territorial jurisdiction, and a different interpretive focus may lead to misreading scope and meaning of article, and it can consequently damage the quality and principles of international criminal law as it sets. Because you see, when we ICC statute is not the sole document; it is further supplemented by elements of crime and Article 22. If I'm not wrong, Article 22 it states the guidelines as to how a law should be interpreted. So scope is very restrictive in nature. And yes, this definitely provides clarity in law, but then it narrows down the applicability of provisions of Rome Statute, and it eventually hinders the scope which is being set out in preamble of the Rome Institute to provide justice at large. A solution is that the court can exercise its jurisdiction under the Asian maritime competence, and by applying this competence, it could prevent judicial overinterpretation in standard matters. But there is still an undiscovered area of ICC. That is when the jurisdiction on conduct of occurring in cyberspace might be found. At this point, this could be asked that how court can exercise the jurisdiction without overstepping the judicial boundaries. Now we do not have any particular solution. A we just have a temporary solution for this, which I stated, but no particular solution or no settled provision we have to tackle this problem. This has been acknowledged. This has been also acknowledged by the prosecutor that we need to match up with expansive advancement in technology. So this is being acknowledged by the International Criminal Code. This is being acknowledged by the scholars, but the only reason which I see due to which we are not inculcating the technical changes, there were Kampala amendments back then in 2010. The technology was in developmental stage. Some provisions could have been inculcated, but what I see through the debates, but what I see through the points which have been made by delegates of various countries, that there is political interest of countries which hinders the institute to inculcate broad provisions in the international criminal law. Now, I'll not read article. I'll read Article 21 for you. It states that the court shall apply in first place this statute, which is the Rome Statute, elements of crime, and its rule and procedure of evidence. The jurisdictional issue at hand should be resolved through application of interpretive principles stated in Article 31 and Article 32 of VCLT, that is Vienna Convention on Laws of Treaties. If there is any lacuna in ordinary sources of international criminal code, as it is mentioned in paragraph 1, it is further stated that applicable treaties and the principle and the rules of international law, including the established principles of international law of armed conflicts, should be applied. Now, firstly, neither the elements of crime nor the rules of procedure entail clarification for the jurisdictional challenge emerged due to cyberspace. Secondly, the Convention on Cybercrime, which we do call the Budapest Convention, remains the only legislation dealing with the crimes relating to cyberspace, and no other international treaty on the subject exists as of now. Only relevant document which was presented in United Nations, it titled Countering the Use of Information and Communication Technologies for Criminal Purpose, and it was passed by the Third Committee of General Assembly in the year 2019. Now it is very clear, very apparent, it is on the face that we do lack the sources, we do lack the needed legislation. And hence the customary international laws and the general principles of international law are the only methods and are the only saviors which can protect the nature of providing justice. They can fill void if applied accordingly. But then, as I said earlier, this is no permanent solution. This is not a settled solution, and there is still uncertainty and vagueness if we tend to apply these principles. Now, focusing on problems with Article 17 of the Rome Statute. Article 17 discusses the issue of admissibility. It is crucial when we uh, when we think to allow an investigation about the accountability of individuals through social media. But it must be then taken into consideration that several nations do not have appropriate laws for dealing with such factual scenarios. This may lead to cases of acquittal of responsible individuals. Sure, what is the time? So in 10 minutes. Perfect. To make it short, so do you want to say anything?
No, just you have 10 minutes to conclude your presentation, please.
Okay, thank you. So I'll sum up my presentation. To understand the complexity in Article 17, let's take where state is genuinely to prosecute the accused, but as we know, most of state
Rabdil, I'm sorry we can't hear you. Well, just one moment. I think he'll rejoin the conference call. Mr. Sharma.
Am I audible to you?
Yes, now we can hear you.
Just a second, let me reconnect.
There are some internet issues, I think.
Hello, is it fine right now?
Yes, we can hear you.
Perfect. So let us consider an example. So when we talk about Article 17, let us consider an example where state has genuinely tried to convict, try and accused, but since most of the states do not have the needed law and there is no guiding light, which is the international light to guide them through this, there most of chance there are high chances that the particular accused will be acquitted due to the lack of legislation. And since that person will be acquitted, and as we know, it's a settled principle of criminal law, ne bis in idem, that a person cannot be tried again for the same offense if he's acquitted. I'll sum up with this, and then I'll quickly state what are the regulatory gaps in Article 25, particularly focusing on the element of public and direct incitement. So when we talk about public and direct incitement, it is some standard which cannot be, which lies in a very gray area when we talk about social media, particularly because in social media there are groups. For example, in Facebook there are private group, there are public group, and there is no line to determine which lies in a public area and which lies in a private area, because there are some group you can just you are just a click away to join the group, and sub group are public. So the number factor cannot be applied, definitely, because it has been disregarded by some scholars, because it is not the right factor to determine. However, what we can apply here is that the ease of accessibility of that particular content on the social media can be applied to determine if the content is public, if the content is public or not, if the platform is public or not. social media is definitely a public platform, uh, definitely a public platform, but the counter arguments might be there that you need a particular ID to sign up there, and hence it is a private platform. But with changing time, the ease of access is been constantly increasing, providing access to almost every person. That particular person must have an internet connection. That's it. So what we can state is that it lies in a public, it lies in a public domain, but the direct element also must also be considered, because in social media there are views of some jargons which are understood by the audience only, and it might not be necessarily understood by the court. So that is something which must be considered by the social media itself, the country heads of social media itself. That's my suggestion with this. I think I am running out of time, so I conclude my paper.
Yes, well, actually, you have still 5 minutes if you have one last point to make.
I've already summed up actually.
All right.
There are many provisions, so I'll not be able to inculcate them all in one.
All right. Then, well, thank you, and Mr. Sharma for guiding us through at least a part of your article, and I think it's also interesting that you highlighted some materials and cases which are not actually in the paper, and perhaps some new issues arose. Perhaps, of course, the media as an actor towards which one can, as a member, rely to form private groups in which to form and make a dialogue about sensitive topics and perhaps relevant things that ought to be considered by international community. Now, having heard Mr. Sharma, I would like to call upon Dr. Caroli, who, as I anticipated earlier, will provide some fresh new perspective on the topic discussed in the papers and now summed up by Mr. Sharma. So thank you, Mr. Caroli, Dr. Caroli.
Thank you. Thank you very much for the invitation, and let me congratulate you first of all on these conferences and generally on your work at this student law review. I always appreciate when students takes this initiative on themselves, and it's clear that you are very motivated and interested and professional in the way you organize it. And congratulations, of course, to Mr. Sharma on his article. Well, I take my role really as a discussant, so I'm not gonna put more food for thought, so to say, because already we have heard a lot of interesting topics. Each one of them would require probably a conference, because there are many relevant issues that have been raised. I like to start by saying, of course, that it's as we have already heard, it's particularly relevant that this observation come from a country like India. Of course, I'm not gonna engage now into a discussion of the implication of social media and hate speech in India, but having in mind, of course, the major role that social media played in the Rohingya persecution in Myanmar. Of course, some news that we hear about coming from India sometimes are quite scary, at least seen from outside. So I'm pretty curious to hear if our panelist confirms this or not. But sometimes it's scary to hear some similarities, so to say. I think in particular of those many fake news regarding the Muslim community as a possible source of spreading COVID-19 in India at the beginning of the pandemic. And so there are, of course, some similarities that are quite scary. and the role of social media as possible vector, so to say, of hate speech is surely one of those. This contribution, it's very interesting because international criminal law is coming a bit slowly to this issue. There are now, we are now beginning the discussions. There are some initial observation, but still international criminal law realized probably too late how the implication of social media. And whereas, as we all know now, each legal system is conscious of the need to intervene in regulating the use of public speech on social media. And now we are aware of that. Now we are aware of the fact that we are dealing with a new phenomenon, and that is impossible to relate to the old discussion that we had before about the limit of free speech, the concept of public speech. Social media like erased all of a sudden decades of discussion about free speech, because we are dealing with a completely new phenomenon. Yes, free speech is part of the problem, but it's not, in my view, and not only in my view, the right angle to look at the phenomenon, because we are looking on at the need of states to protect common interests that can be relevant, such as the right to information. In particular, Reporters Sans Frontières issued a declaration which says that the collective right of information should be regarded as protected interest of a possible crime in relation to the use of public speech on social media. And so the other possible, but in general terms, the protected legal interest refers to public security, to public peace. There are, I think it's quite interesting to that the discussion on hate speech on social media goes parallel with the discussion on ecocides, because they are two different crimes that attack the common interests that are at the basis of our society, like our planet, our public space as human being. But both of them seem to be in contrast or with the traditional categories of criminal law, which probably is not the best tool to fight this phenomenon. And so there's really this parallel discussion about at which level should government intervene. Is criminal law the best tool? Is international criminal law the best tool? Or should we have new crimes? Should we choose other instruments? And so as I said, at national level, nowadays we have reached the point that each legal order seems to be under stress because of the use of hate speech on social media, and everybody agrees on the need for an intervention. The problem is, how should we intervene? We have seen many different models in most recent years. We've seen, for example, the German model, which does not introduce new criminal provisions, but ask social media to apply the existing provisions. So not only they allow social media companies to control us and to censor what we write, but they ask them to do it, because if they don't, it's them that are punished. So, for example, last year, Germany condemned Facebook for not removing a hateful post from a user. There are a different method that's been used by France, which focus more on communication about the user, about who pays some Facebook pages, for example, if foreign state controls a Facebook page. Then there are very repressive solutions, such as that of Singapore, which is very quite frightening from a Western point of view. And but going back to international criminal law, still we are really not that far. We don't have really possible solution, but yet it's true that it's definitely true. We're seeing it in Myanmar that social media can play an important role in the commission of crimes, in particular in relation to incitement to genocide. But are the criteria that we have sufficient to apply criminal law to this new phenomenon? And I particularly appreciated what the author of our article and our presentation today wrote when he says in his article, some questions would arise as if the mere but voluntary presence of a person in a social media group inciting to genocide is sufficient to meet criminal accountability, and if passive adherence is considerable enough. Moreover, should be thought how to determine the threshold of an active behavior in the social media era, and if a like or a shared post could be a decisive element to configure an active conduct. That's very interesting because, and in that I see a similarity also with ecocide. The dangerousness of those behavior on social media is not really the propaganda effect of the single speech, of the single post, but the fact that this post can be shared and liked by millions of users all over the world. And then the problem is that sharing, is that like criminally relevant? Of course, that is what makes this post dangerous, the fact that this is shared. But can we bring criminal law that far to say that just quickly sharing a post on our cell phones in 2 seconds is incitement to genocide, for example? And also thinking about the person who writes um, the hateful post. If you think about social media, the power of social media is that if I take my cell phone right now, maybe when I'm doing other stuff or I'm just waiting for my, excuse me? No, okay.
And probably that was a mistake, someone with the microphone open.
Okay. So I was just saying that the power of social media is that maybe if I'm just waiting for my train or going back home in my bus, and I just quickly write something which takes me 2 seconds without thinking, that quick post can reach billions of people all over the world and even probably incite to genocide. But does it mean from a criminal point of view, criminal law point of view, that I had all the relevant prerequisites of the mens rea, and did I provide, of course, from an objective point of view, I provided for a contribution. Of course, this can be said is propaganda because it's much more effective than going every day with my flyer to people and maybe reaching 10 or 20 people. But and this, I like to quote in this case 2 different decisions in Italy regarding racist propaganda on the internet. Both cases were cases of young girls who wrote hateful posts. I remember one case, for example, was a girl from an influencer from Padua who was like on a train next to a Romanian who she said was smelly, and she writes and then she writes on her Instagram account, I think, oh, I hate Romanians, they are all smelly, I want them to go away, I want them to be killed. I don't know what she said. And then, of course, she was convicted for racist propaganda because, of course, she had like thousands of followers, and so that was propaganda. But the judge says, considering the fact that she did it, like wrote it quickly while she was waiting on the train, and then she never took the cell phone back, or the system, the social media did it all by itself, the sentence that we give her should be very low. On the contrary, we have a decision in Tuscany, which for a very similar case, which says precisely because she knew where she was right in that, precisely because she knew how many followers that person had, she didn't choose to tell this claim to a friend at the bar, but she wrote it on social media. She should have been aware of the consequences, and she deserves the highest sentence. So this is just an example to show you how, even if we accept a role of criminal law or of international criminal law, how then in practice, how difficult it is to apply those categories who are thought of for a very different world to the cyber world, and the social media in particular. I think I will stop here. I would just like to ask probably to our panelists what he thinks about, because he writes clearly that the existing norms are not sufficient. So I'd like to know if he has an idea where this intervention should be, if we need, I don't know, a new international crimes or a different international crimes, or if legislators should intervene at national level, or if he thinks that probably criminal law is not the best tool to face this phenomenon, and that there are other options. I'm just curious about his view. Of course, there is not, as I've said, there is not a good or bad answer to that. So I think I can stop here.
Well, thank you, Dr. Caroli. I think and I hope sincerely that your contribution will spur some debate with the author, but also with the rest of the public. And I want to say that preparing for this conference, I tried to think of a couple of questions I could ask first to you, Dr. Caroli, and then to Mr. Sharma. And one of those was about the former perspective that I think can relate to what you just said. I think that the trouble here is that all what Mr. Sharma exposed in his article is about custom and about the courts declaring that some actions, the hate speech or the incitement to genocide is subject to their decisions, is something that they are competent in condemning. And I was thinking about the famous Latin phrase nullum crimen sine lege, and I was thinking, but can really a court decision, a custom in international law, declare that crime, that a provision that from a treaty expand its meaning to lead to sentence, to condemn a person that has done something not completely different, but really not really what it was intended for. You know, the provision extended such an extensive interpretation of provision in international criminal law. And that's my question relating to what you just said to you.
Do you want me to answer?
Yes, please. Yes, just because there's some continuity with what you just said.
Okay. Well, of course, there's it's an interesting question. I'm not sure that it will really be a problem of non criminal legge, because it's not, as far as I see it, probably it's not really that a different typical offense, because in particular, of course, it depends then which crime we're talking about. But if we're talking about, in particular, incitement to genocide, the Rome Statute doesn't say that this incitement has to be to have a particular form. So it does not per se exclude social media. I remind that the first case of incitement, well, we had a former example that of incitement to genocide, although it was not called like that, at the Nuremberg tribunal in the Steichel case, which refers to the use of newspaper, to the newspaper Der Stürmer. And then we have, of course, the first application at the Naimana case, in the Naimana case, at the International Tribunal for Rwanda, which refer to the use of radio. So I wouldn't see that as a very as a violation of strict legality, precisely because this provision does not envisage a particular way of public speech. Then we can discuss, of course, about this nature of public speech. That's really the main problem, and also the problem behind the regulation of social media, because social media have the access, the access to social media is more similar to private space, but their impact is really the most collective as possible. We had two decisions in Italy last year regarding the removal of the Facebook page of the right-wing organization Casa Pound, and one of the decision motivated the legitimacy of the removing of the page because Facebook should be considered a public space, and then we should apply the principles that we apply to other public spaces. And that's probably the main problem. And yeah, so I see there is a problem, in my view, of the applicability of the existing international criminal law to this new phenomenon, but it doesn't really relate to the crime in itself, but rather, as I was telling before, on the prerequisites, on the point of view of contribution, on the point of view of the mens rea, and which, of course, has to combine the two phenomena. The fact that now the effect is not connected to one conduct, such as the case of Steiger, who was the journalist writing those anti-Semite articles, but to the summing up of individual conducts. And but the problem is, how far can criminal law go in reaching our private life if it reaches to the point that one single post is to be punished because of violation of public interest. The most terrifying example in this view is Singapore, where in practice the law gives to the government the power of punishing whoever posts whatever that can constitute a threat to the public order, which in one way solves all our problems, but on the other, that bring us back to the worst times of our dictatorships that we have. And so behind all that is the fact that, of course, the so-called disintermediation aspect of social media, the fact that social media give to each one of us a direct power of public speech and public intervention that sees no precedent in history, because it has never happened that each one of us ever has a direct access to the public speech to reach the whole world, possibly without any control, any selection. And that, of course, is behind the idea of criminal law itself, is behind every possible intervention. So I think it's true what you say, but I fear that it's a bit more complicated than that.
Yes, well, perhaps I expressed not completely correctly, because I was meaning the ICC competence on judging, what's the threshold after which the ICC is involved. Perhaps I expressed myself wrongly. It's not really, yes, I understand incitement to genocide is an open formula, but there's who's competent. The Rome Statute and International Convention do not say who's competent in, perhaps not genocide, because they're perhaps a little bit more clearer, and perhaps they're prerequisite to bring charges in front of the International Criminal Court are clear, but there is this intermediate gray zone in which I think
it was clear, and I do agree about it. I just focus on genocide, and that's connected to the question that I had for the panelists, because it's, as you say, it's a gray zone, and we don't have actually now a treaty say that the solution should be found at international level. It could be a solution, because as we see now, states seem to be really weak and not able to control social media, and on the other hand, probably to face the big power of these tech companies, an international solution would be better. But that's a totally open path so far. So we don't have any solution in that direction for the moment.
Yes. Thank you. And now I would like to ask Mr. Sharma to perhaps comment on the remarks of Dr. Caroli, in particular those referring to Singapore and the situation in neighboring countries he made during his discussion.
Thank you for your question. So, yeah. Hello, am I audible?
Yeah.
Yes.
Okay. So before beginning, Mr. Carroll stated some cases regarding sharing and liking of the post. In that particular regard, that there is a very landmark case that is celebrated in India. It is Shreya Singhal versus Union of India. Now, this has some political connection in it. A law student, Shreya Singhal was a law student. So she liked a post and shared a post which was criticizing government, and then an FIR was launched against her, and then she was convicted. The girl went to the Supreme Court of India, and then eventually Supreme Court took the angle of that free speech, that due to such posts, these posts are in the ambit of free speech. So what we can say is that there must be a line where we can differentiate between free speech and a content that exceeds the reasonable restrictions which must be there in a free speech. Those reasonable restrictions must be public order, morality, decency. These all things which can be then settled by the court. Now, when we talk about the power of social media, I cannot resist myself to state an example. So there is a book that is called Like War. Now, it's a very interesting book. It helped me a lot in framing my mindset about the social media, the research. So there is an incident in that book which states that social media is so powerful that it glorified the terrorist organization like ISIS. So when ISIS was planning to attack a particular city, they posted their men in the black uniform and all posing with lavishing guns. So what did that? What the consequences of that post was the most of the fools, they fled away due to the terror of ISI, the social media terror of ISI, interestingly. And then that enabled the terrorist organization to capture it very easily. And another thing which I would like to point out here, is the social media is like a net. So everyone is traceable. And if a particular person is not using social media, then that is also traceable because of the void which is being created in that particular net. Yeah. And then coming to question, that what solution do I particularly suggest with this regard? So one thing uh, which can be possible is that whenever a case like this comes, can be tried by court, or a long-term solution which can be there is that there must be discussion, that the discussion must be initiated in international bodies and international convention. I would like to appreciate European Union in this particular regard, because they took the step in this furtherance. The nation should also take steps to acknowledge and to recognize the importance of internet, the importance of data. India in particular has uh, passed a bill that is called Personal Data Protection Bill, which I personally think it's a step forward to acknowledge the advancement of technology. And it will and the IT Act. So there are some provisions which covers the cyber crime, the crimes which are being committed in cyberspace. So this was my solution, that states must take steps. There must be some states. I particularly think that India must be one which can lead in this way, because we are a multicultural country, and it is, um, it's easy to offend people. We have Muslims, we have Christians, we have Hindus. So a multicultural country like India knows best how to manage manage the protection from racial propaganda on internet and all these things. So this is one thing which can be done, and then later discussed in international community, and then scholars to play an important role in international law, and hence work must be carried out in this particular field. This will be my answer to your question. I hope this satisfy.
Yeah.
Well,
Sure.
yes, I think that the perspective is interesting. I want now to perhaps open the discussion with the rest of our followers in this moment. I would like to, and perhaps there is another perspective that can be considered. I mentioned in my opening remarks that social media started an activist, let's say, policy. They started removing posts, they started closing accounts of politicians, and thus selecting with more rigor what can be posted and what can't be posted. And I want to ask our author, Mr. Sharma, and also Dr. Karoli, if this starting to choose to cherry pick well, not quite cherry pick, but really to choose to disband, to remove from social media contents, or even entire profile of perhaps even relevant personalities in political sphere. This elephant in the room is Mr. Trump, former president of the United States, which was completely removed. But my question is, by taking such an active approach to what can and what can't be published on the social media, is there perhaps the case to say that the social network get more responsible for what is published? Because in the moment they start choosing what can't be published, the obvious consequence is, well, if the social media leaves hateful speech, or don't know, there's a bit of, it's the African general that, let's say, put it this way, the African general that incites genocide on a profile. Just a moment, Mr. Sharma is writing. Yes, he asked to please, Dr. Karoli, you answer first to this question, because so he can prepare to remark on this. I was saying that is the social media then more responsible and how can the social media, the corporation, because they are all big tech corporations, how can they be made liable, and are they to be made liable? Because, you know, in America in particular, there is a debate about the liability of social media, and new grounds have been broken by, you know, Trump being removed by social media. Hence, in connection with the topic of this paper, I think there is something to it.
Yeah, that's surely the topic. And interesting enough, criminal lawyers for months now had been writing that it's wrong to apply criminal law. The criminal law is not the best tool, and that social media should be responsible, should get responsibility. And as said, we have the German example where Germany not only encouraged social media to do this, but punished Facebook not for doing it. And then when it happens to Trump, because of course Trump was the one in the spotlight, so social media could not not see Trump after Capitol Hill, the events of Capitol Hill, and then and then everybody criticized social media for doing it. I think that the point is not if social media can or cannot um, delete someone's page or ban someone from social media like Facebook and Twitter did with Trump. But the problem is how they do it, who does it, and are these procedure and these criteria public? Honestly, I think that if these procedures are made public, they are clear, and we know who is controlling what, this could be the best solution. The problem is, I do invite all of you to watch this uh, very well done but terrible in its content documentary called The Cleaners, which tells the story about those people in the south of the world who do this job. They are the one who clean our post, paid less than nothing, and they have a rhythm of really they need to check like I don't know how many posts in 1 minute, and to say yes or no on the basis of general criteria that are given to them. And it's a terrible job, a terrible life for them. And interesting enough, many of these people, after working in this condition for months, become like member of those conspiracy groups that they had been deleting. They become conspiracy theorists. They become racist extremists and so on. So this is really the problem, and therefore the problem behind the problem is uh, should we limit the power of those companies? Should we allow those companies to have a monopoly? Are we not to consider those companies as the new means of productions of the 21st century, considering that no business in history ever made that much money so quick as those companies are doing nowadays. So probably this is the real problem. Not talking about the limits of free speech, but how do we deal with these companies? How do we do? I said, is it acceptable that one company has such monopoly? Who makes these rules that says that a post can be there and the post cannot? Because if that's a public space, then also the rules that are made for that space should follow public and democratic procedures. At which level? National level, international level? That's a good question. But if this is a public space, they should not be treated as simple private companies who establish their own rules. So this is the point, not the point that someone is banned or not, in my view.
Yes, yes, I understand, and yes, I was trying to make the point that and this my question was indeed similar to this you're putting. It's how to implement this, how is the best way to stress companies, to put pressure on the companies, how to achieve this through criminal law. That's really the big picture of the question I was trying to deliver. And yes, you answered, and I would like now to hear Mr. Sharma, who asked some time to prepare his remarks on this topic. And interestingly, India is living now a particular moment. There are protests also organized through the media, and perhaps we can gain some interesting insight in how this situation is managed. I don't know. I'm asking Mr. Sharma. Thank you.
Your question was what should be the method to stop the hate speech content on social media, right?
Yes, really, with Dr. Caroli, we tried to enucleate how to put pressure on the big tech companies, how to, regulate. Are the big companies more responsible, big tech companies, social media more responsible when they choose, they become they choose to leave, I don't know, a hateful remark. And Dr. Carli was underlining the fact that there are, in the documentary he mentioned, the cleaners, there is this narrative on how this selection of posts of content on the social networks is made, and there's it's big question, it's a big picture, and how to put a pressure on social media, and if criminal law is the most appropriate tool or not, or
Yeah. So what I think is, first of all, to set up the accountability, it won't be viable to directly say that we must have a law against them, because international community has indirectly agreed that their regulation must be, there must be a self-regulatory code to regulate social media platform, because this is more likely to hinder free speech. Because what I see in India, what I see in the politics of world, the politicians, the world leaders, they are more likely to misuse that particular law in their favor to suppress the dissent. Now, when you talk about India, similar thing is here. The government, there's a propaganda of government. They continuously try to discredit the protester by calling them anti-nationals, by applying the seditious charges on them. So what I think is, on the part of social media, what we can set up is, whenever they put an action, there must be a proper reasoning for that action. That proper reasoning must be emailed to the stakeholders of that particular content. For example, if X person posted a particular content and Y reported it, then then a proper reasoning of as to why the post has been removed, or why the post has not been removed, must be sent out to the both X and Y, and then that must be open to challenge. What we can do is, we should not overburden courts in this. We can use a hybrid method of online dispute resolution, that will allow us to move in forward of dispute resolution system, first of all. Then what I think is, that will set up more accountability, that will set up an example, and people will not, as Mr. Currently said, that people will not just put a yes or no. They'll have to analyze the particular post. There will be more people who will be employed in this job. There'll be proper reasoning which shall be provided, that and that has to be provided a person who has knowledge of that particular content, because when we ask for reasoning, we ask for proper reasoning. So that is what I think can be applied. I don't think that applying a strict law is direct solution to the tech companies, because if there are cons of social media, there are pros of social media. In India, I've seen example where just a tweet has saved some lives. A tweet has saved a woman from getting raped. So it has pros and cons, and most of time it helps to protect democracy also. So it should not be restricted directly, but I think these methods can be set up.
Yes, I understand. And thank you for your answer. Now, I would like to ask if any of our followers have questions for either our author, our discussant, or both of them. I don't think so. No. Then I should like to thank Mr. Swapnil Sharma for choosing the Toronto Student Law Review as a venue for his work, and for participating at such a late hour, because in India it's particularly late at this time of night there. And I'd like to thank again Paolo Caroli for his intervention at this conference, and I would like to thank the Toronto Student Law Review for the opportunity of presiding over this conference. And you know, even though it's not really custom, I shall like to wish everyone good night, and I invite you to the next conference, which will be publicized on all social media of the Toronto Student Law Review very soon. Thank you, everyone.
Thank you. Bye-bye. Have a nice evening.
Bye.